Okay, so good day po taong bayan at ngayon po pag-usapan natin yung most recent development po sa case ni Vice President Sara Duterte, yung Duterte po versus House of Representatives kung saan nanalo po si VP Sara with a unanimous decision 13-0 po kung saan dineclare ng Supreme Court as unconstitutional yung 4th Articles of Impeachment. So yun po yung last na nangyari and ngayon po yung latest development is the House of Representatives has filed a motion for reconsideration despite po that unanimous decision. Okay? So yung magiging discussion ko po for tonight will be based lang po dito sa statement ni Speaker Martin Romualdez kasi currently po hindi pa available yung full text ng MR nila. Wala pa po sa Supreme Court website and yung mga nakikita ko lang po sa news article is yung title lang, yung header and then yung prayer lang. But yung prayer naman po nila was more or less covered din naman po dito ni Speaker Martin Romualdez. Okay? So yan po yung magiging discussion natin for tonight. So kung mag-enjoy po kayo sa video na to, huwag niyo po sana kalimutan, i-like po mismo yung video and of course po mag-follow or subscribe din sa channel ko para po updated kayo kung may bago tayong upload. Okay? So unang-una po, i-discuss natin yung first issue natin.
It is an act of duty. We do not challenge the authority of the court. We seek only to preserve the rightful role of the House, the voice of the people, in the process of accountability. Let us be clear. The Constitution says the House of Representatives shall have the exclusive power to initiate all cases of impeachment. That power is not shared, not subject to pre-approval, and not conditional. Yet, in GR number 278353, the Supreme Court ruled otherwise, based on a misreading of facts and a retroactive imposition of the new rules. On February 5, 2025, the House transmitted the 4th impeachment complaint, filed and signed by 215 members, to the Senate. Only after this transmittal did we archive the earlier 3 complaints. The sequence matters. It proves there was only one valid initiation, not 4.
So doon po wala namang question dyan kasi hindi naman yan kinukuha ng Supreme Court sa kanila, di ba? Yung ginawa lang po ng Supreme Court dito was that they exercise what we call the power of judicial review. And like what I've already explained before, that power po is absolute, di ba? So ipakita ko lang po ulit sa inyo para klaro talaga tayo. So kung makita po nyo Article 8 Judicial Department Section 1 sa paragraph 2 po yan, judicial power includes the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable and to determine whether or not there has been grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. So like what I've also explained before, kung makita po nyo, yung power of judicial review of the Supreme Court is absolute considering that ang nakalagay po sa Constitution mismo on the part of any branch or instrumentality of the government. Subject only to the requirement po na dapat may grabing pang-aabuso ng discretion or kapangyarihan yung government office na yon. So kung meron pong grave abuse of discretion, pwede po mag-step in yung Supreme Court para interpret kung ano talaga yung proper application ng Constitution, ng batas natin dun po sa kaso or sa situation na pinag-uusapan, di ba? So yun po yung ginawa ng Supreme Court dito. They interpreted that there was grave abuse of discretion ng Congress kasi po tinulugan ng Congress yung first 3 impeachment complaints. Okay, so i-explain ko na lang din po yung so sinasabi kasi nila Speaker Martin dito is that nag-overstep daw yung Supreme Court by reviewing the decision or the actions of the House of Representatives in relation to initiation of impeachment complaint. Okay? So kung i-apply po natin yung ganung explanation dito ni Speaker Martin, again with respect to him, it will lead to an absurd situation po. Okay? So ito po, bigyan ko kayo ng example para mas maintindihan po ninyo. So ito po, let's start with the side of Congress. Kung yung Congress po gumawa ng unconstitutional na batas, ibig sabihin pala nun ngayon hindi na pwede yun reviewin ng Supreme Court because again, the power to legislate po is specifically given to Congress, diba? Section 1, Parang ganun po kasi yung logic ng explanation dito eh. So pag ganyan, again, hindi po yan ganun kasi Article 8, Paragraph 2, pwede nga reviewin ng Supreme Court as long as there is grave abuse of discretion. So similar din po yun sa initiation of impeachment proceedings. If there is grave abuse of discretion, since absolute, hindi po accepted yung impeachment proceedings naman like what I showed you earlier, therefore pwede exercise yung power of judicial review in relation to impeachment proceedings. Okay? Tapos ito po, bigyan ko pa kayo ng isang example sa executive naman. So 'di ba yung Congress gagawa ng batas? So for discussion purposes, para po mas madali, sabihin na lang natin na yung batas na inanak po ng Congress is dumiretso lang yung executive branch pag i-implement nila yung batas. E paano ngayon pag biglang ginawa ng executive, lumiko sila sa left instead na dumiretso? Ang question dyan ngayon, hindi na naman yun pwede reviewin ng Supreme Court because again, the power to implement laws, to enforce the executive power is constitutionally given to the executive branch. So ibig sabihin, hindi rin po pala yun pwede reviewin ng Supreme Court. Again, hindi po yun ganun because the power of judicial review is still absolute provided na there is grave abuse of discretion. So ganun po yun. Dun sa example ko, yung executive, meron silang grave abuse of discretion kasi lumiko sila sa left, yung sabi ng batas, diretso lang dapat. Okay, parang ganun din po yan. Ang nangyari po dito sa case na to, ang sabi ng Constitution, there should only be one initiated impeachment complaint within a period of 1 year. Unfortunately, they initiated 4 impeachment complaints kaya nagkaroon ng grave abuse of discretion. So okay, so explain ko na lang din po yung setup talaga ng internal rules ng House of Representatives ngayon. So sa Constitution po natin in Article 11, ipakita ko na lang din po para ma-sure talaga tayo. So ito po, Section 3 of Article 11, it states here that a verified complaint for impeachment may be filed by any member of the House or by any citizen upon a resolution of endorsement, which shall be included in the order of business within 10 session days and referred to the proper committee within 3 session days thereafter. So kung makita po ninyo, upon filing of a complaint, dapat talaga malagay na agad siya sa order of business within 10 session days, tapos ma-refer sa committee, which is the Committee on Justice, within 3 session days. Yung naging dilemma po kasi dito sa situation ng House of Representatives, yung sa mga 3 impeachment complaints na final nila, the current setup po kasi sa internal rules ng House, meron silang added requirement na kailangan mo na i-file daw sa Secretary General's office. And then pag file sa Secretary General's office, ngayon yung Secretary General has the control kung kailan niya i-file or ipapasa sa Office of the Speaker. Tapos pagdating po sa Office of the Speaker, dun lang bibilang daw ng 10 session day requirement as per the House of Representatives. Yun yung argument po nila. And this legal theory po na i-explain ko lang sa inyo ulit, I have been explaining this already since February, na yung ganung setup po ng House, yung ganung rules nila na may dadaan muna sa SecGen's office, sa Office of the Speaker. Kung ako po tatanungin, yung professional assessment ko po of that internal rule would lead to a violation of this provision po of the Constitution natin. Kasi yung added requirement ngayon na dadaan muna sa SecGen's office, then sa Speaker, dun pa lang po madidefeat na yung purpose and essence ng 10 session day and 3 session day requirement kasi pwede nga ngayon i-dribble or kontrolin ng Secretary General's office prior to him filing it to the Office of the Speaker. And as a matter of fact, in the Supreme Court decision po dun sa Duterte versus HOR, tinakel po yan at diniscuss po yan ng Supreme Court dun na yung inaction daw ng Secretary General constituted a violation po which resulted to the 1-year bar rule. Kaya po sumipa yung 1-year bar rule. So yun po yung summary in a nutshell in relation to this provision dun sa Duterte versus HOR case. So ngayon, ang sinabi ni Speaker Martin dito is that in-archive lang daw nila yung first 3 impeachment complaints after na nila na-transmit yung 4th articles of impeachment. Pero like what I stated nga po, if you read the full text of the case, hindi po ganun yung appreciation ng Supreme Court. Due to the inaction po of the Secretary General, pwede na at sumipa na po yung 1-year bar rule because of that inaction. Okay, so yan lang po yun. So again, ulitin ko lang po, wala po tayong issue or question na yung sole power to initiate impeachment proceedings is with the House of Representatives. However, ito po sa explanation ni Speaker Martin Romualdez, with due respect to him, I beg to disagree po na it's a violation of the checks and balance because it is very clear po sa Constitution natin, Article 8, Section 1, Paragraph 2, absolute po yung power of judicial review subject only to the requirement na dapat may grave abuse of discretion. And like what I said, because of the inaction of the Secretary General's office, that resulted to the grave abuse of discretion kaya dineclare as unconstitutional po ng Supreme Court yung 4th impeachment complaint. Okay, so hopefully klaro po tayo as to the first issue dito. Kung tatandaan po natin, dito kasi sa Duterte versus HOR case, kinlarify ng Supreme Court that the right to due process must be protected in all stages of the impeachment. Therefore, yung right po ng isang impeachable officer to be heard or to explain herself should also be given to her even dun sa initiation stage pa lang. So yung ina-argue ngayon ni Speaker Martin dito is wala daw ganung requirement na dapat mag-answer si VP Sara as the impeachable officer dun sa initiation stage. Tapos tama din naman siya na yung dati pong precedent or yung dati pong jurisprudence is that in the old jurisprudence po, yung Francisco versus HOR, initiation is considered only upon the referral only to the Committee on Justice. Pero hindi po ako agree dito kay Speaker Martin, again with respect to him, na hindi daw pwede magdagdag ng procedural matter yung Supreme Court or that hindi pwede mag-apply retroactively yung mga procedural matters na dinadagdag po ng Supreme Court. Hindi po ako agree doon and I will show you a specific case regarding that issue. So ito po yung case tungkol sa impeachment ni Ombudsman Gutierrez before. Okay, so meron pong legal principle na na-establish clearly yung Supreme Court din dito eh. So ito po, this principle here. So unang-una po, I will clarify. Alam ko na this has a different set of facts naman itong kasong to from the case of the Vice President. However, if the Supreme Court talks kasi, that forms part of the law of the land, di ba? Mga legal principles na po yan. Tapos dito po, makikita natin very clear yung sabi ng Supreme Court. Sabi ng Supreme Court, the rules on impeachment as contemplated by the framers of the Constitution merely aid or supplement the procedural aspects of impeachment. Being procedural in nature, they may be given retroactive application. It is axiomatic that the retroactive application of procedural laws does not violate any right of a person who may feel that he is adversely affected, nor is it constitutionally objectionable. The reason for this is that as a general rule, no vested right may attach to nor arise from procedural laws. In the present case, petitioner fails to allege any impairment of vested rights. Okay? So ito po, because of this legal principle, babalik tayo ngayon sa remedial law 1. Okay? One of the very foundation and basic principles of remedial law or procedural law po na subject sa law school. So this one po, I believe I was in my second year po. I more or less or second sem ng first semester. Hindi ko na rin po maalala kasi tagal ko na po nasa law school. But anyway po, this is a legal principle that is discussed po sa remedial law 1. The very first remedial law subject po ng mga law students. Okay? And again, this is a fundamental or basic principle in remedial law. So yung remedial law po pala, explain ko lang din ng konti. Yun po yung mga batas natin that governs mga procedural matters. Okay? So sa remedial law, ang basic po talaga dyan is that being procedural in nature, they may be given retroactive application to pending actions. Okay? Yan po ang basic in remedial law. And the reason kung bakit pwede mabigyan ng retroactive application yung remedial law amendments sa mga pending actions is because wala pong karapatan na nag-a-attach sa mga procedural na bagay. Okay? So in other words, it is legally incorrect if you ask me po to state na hindi pwede mag-decide yung Supreme Court na mabigyan ng retroactive effect dun sa pending case ni Vice President Sara Duterte considering procedural matter po yung decision ng Supreme Court. Specifically as to the issue po kung what constitutes the initiation of an impeachment complaint. Diba? And in this case po, in the case of Ombudsman Gutierrez, can clarify that the rules on impeachment as contemplated by the framers of the Constitution merely aid or supplement the procedural aspects of impeachment. In short, kahit na po it is a rules of procedure sa impeachment, it is still treated in the same way as basic procedural law or remedial law po in that it may be given retroactive application to pending actions. Diba? So again, this is very clear. This is a Supreme Court decided case already. Yung retroactive application, this is the general rule po sa remedial law. However, that is subject to exceptions naman po. Okay? Okay, so yung first po niyan is number 1, kung yung batas or yung decision ng Supreme Court mismo ang nagsabi na hindi siya applicable retroactively. Dito po sa case ni Duterte versus HOR, wala naman po tayong makikita na hindi retroactive application yung procedural matter na inexplain ng Supreme Court. As a matter of fact, dineclare nga nila as unconstitutional at inapply nila yan dun sa pending case ni VP Sara. And then yung second exception po to that general rule is whether or not meron bang vested rights that will be impaired or meron bang mga karapatan na maapektuhan. Okay? So kung titingnan po natin yan dito sa case ng impeachment, ang nagbabanggaan po dito is unang-una yung right to accountability against impeachable officers po. Okay? So ang next question po natin dyan, is there vested rights there po ba? So sa right to accountability, of course we have the right to accountability against our public officers because that is clearly and expressly provided by the Constitution. Okay? However po, yung kapangyarihan natin to hold public officers accountable, it must be done in accordance with law, which means kailangan po sundin at protektahan din yung right to due process ng mga impeachable officers. Hindi po pwede i-railroad, i-shortcut, or mag-lead ng abuses pag in-exercise po natin yung right to accountability natin as the Filipino people, okay? Because we have to remember the right to due process is also an established and vested right given to an impeachable officer. So dapat po maging balanse po yung korte natin dyan at pagbanggain talaga sila ng maayos. Hindi pwede mas lamang yung isa na right to due process or mas lamang yung right to accountability natin. Hindi po yan ganun. And dito po sa most recent decided case ng Supreme Court dun sa Duterte versus HOR, kinlarify ng Supreme Court na the right to due process must be fully preserved and protected in all stages of the impeachment proceeding. So dun po makikita ninyo na binabalanse ng Supreme Court yung right to due process in relation to the right to accountability po ng taong bayan. Okay? So hopefully, klaro po yun. Medyo technical po but I hope po na naintindihan nyo pa rin. Okay? So anyway, i-rephrase ko pa po one more time para mas maintindihan maintindihan po ninyo. So there are two rights here na nagbabanggaan, right to accountability versus right to due process. So in summary po, dapat pag i-exercise yung dalawang rights na yon, walang mas lamang. 'Di ba? Dapat yung right to accountability should not violate the right to due process and vice versa. Okay? And then yung last exception po to the general rule na procedural laws can be given retroactive effect is whether or not it will create an injustice po ba to the pending case. Okay? So kung ako po tatanungin, ang professional assessment ko po is that it will not create an injustice. Okay? Kasi kung tatandaan po natin, yung right po natin to hold an impeachable officer as accountable ay hindi naman po nawala, di ba? Hindi naman natanggal. Kasi pwede pa naman po mag-refile ng impeachment complaint next year against that impeachable officer, di ba? So kung makita po ninyo, the right to accountability has not been removed. It is still there. Nagkaroon lang ngayon ng konting delay because of procedural lapses ng House of Representatives. Therefore, kung titingnan po natin yung three exceptions po to the general rule, which is number one, dapat sinabi ng decision mismo or ng batas na it will not be given retroactive effect. Wala po yun dun sa Duterte versus HOR case. Pangalawa, yung vested rights, will it impair vested rights? Like what I explained, it will not also impair vested rights. And number three, like what I also explained, it will not create an injustice because we can still file the case next year po, provided na ma-fully comply na yung mga procedural guidelines laid down and set and established by the Supreme Court in the case of Duterte versus House of Representatives. Okay, so hopefully klaro po yan. And then ito lang din po, gusto ko lang din i-clarify because I am always being called the quote-unquote favorite DDS lawyer po eh. So I will just like to explain myself lang din po. Ito po kung wala po kayong political biases, hindi kayo political fanatic, tanggalin nyo lang po yung pangalan na Sara Duterte dun sa Office of the Vice President, tapos i-apply nyo po tong lahat ng dinidiscuss ko. Ano po ba yung magiging tingin ninyo? Tingin po ba ninyo mag-iiba yung application ng batas dito sa lahat ng in-explain ko? Of course, it will not be different, diba? It will be the same. Ang nangyayari lang po kasi, ang nakikita ko, because of our political ideologies, our political fanaticism, because of the hate po of certain individuals against certain political figures, minsan nagiging blinded na tayo, tapos nakakalimutan natin or naiisip natin or ang tingin po natin may biases yung batas. Pero again, like what I said, hindi po yan siya ganyan, diba? Tanggalin nyo lang po yung pangalan na Duterte, tas kung tingnan ninyo objectively, critically, i-assess po ninyo, mag-iiba ba yung application ng batas? Of course not, diba? It will still be the same because the law is law. Kaya nga nila sinasabi na justice is blind, diba? Nagkataon lang talaga currently, mas madaming legal principles na pumapabor sa sitting vice president, but it does not mean that I am biased or the Supreme Court is biased to a certain person. Hindi po yan siya ganun because yun nga po, ang batas po ay batas kahit na po na sino ang tao na involved. Okay, so anyway po, medyo mahaba na tayo. Ang main point ko lang po talaga, maging objective po tayo at critical thinkers talaga. Wag po tayo maging political fanatics, wag po tayo mabulag sa ating mga political ideologies just because we hate certain political figures. Tingnan po natin kung ano yung batas at tingnan po natin kung tanggalin ninyo yung taong involved sa discussion, kung mag-iiba ba yung opinion ninyo. At kung mag-iiba po yung opinion ninyo, then most likely or more or less po, meron kayong political biases or you are a political fanatic. Okay? And if that is the case, you should self-reflect at tingnan po ninyo ng mabuti kung ito bang pagiging political fanatico ay makatulong sa bansa or makaka-apekto. Okay? Yan lang po yung gusto ko talaga i-emphasize because again, these videos of mine, yung main point ko lang po talaga dito, I want to share the law, how it applies to current events. Kasi yung mga public figures po, of course, sila Speaker Martin, and then let's say sila Senator Risa, sila Senator Bato de la Rosa, Senator Bongo, alam po natin na may biases talaga sila because they come from political groups, political parties, diba? So dun po ngayon papasok yung role natin as the Filipino people, as the taong bayan, to be objective observants and objective voters po sa bansa natin. Okay, wag po tayo, in other words po, in summary yung point ko talaga dito, wag po sana tayo magpabola or magbulag-bulagan because of the messages po of yung mga political figures na nilulook up to po ninyo. Okay, so hopefully klaro po yan. If you like more legal videos, may lalabas po yan dito na i-recommend YouTube algorithm sa inyo. And if you want to be notified kung may bago po tayong upload, subscribe lang po kayo. And until next time, see you all po. Bye-bye!